And as we were talking about the Affluenza team, I don't know, maybe he's got a cold too. The Affluenza team, he goes back for a 2-year jail term after they get him back from Mexico, and so I'm my mind is blown as to how this happened. So I thought I would call in a legal expert. So what we did is we got a hold of Scott Palmer from Scott Palmer Law, and you find him at scottpalmerlaw.com. Now, Scott is an attorney in Texas, although not working on the Ethan Couch case. So I think this is important. I wanted to have somebody that had that perspective of exactly what that tone is in Texas. And Scott, welcome to the show here. How is it a guy who kills 4 people and then takes off to Mexico, violating his probation, only gets 2 years? To me, it seems like that would be almost an instant ticket to 8 to 10.
Well, you need to understand that the 2 years that he got is a condition of his probation. So the judge in Texas, every judge in Texas on the felony case has up to 180 days to give a person to do jail time during the condition or during the time they do probation. So the judge in this case decided the day or the week that Mr. Couch started his adult probation, he was going to give him 2 years, which is 180 days stacked 4 times. This is rare to see, but there's also, it's not often the person has 4 intoxication manslaughter charges for which he pled guilty when he was a juvenile. So the case was transferred when he would turn 19, which was Monday.
Oh.
And as a condition of his probation, he is going to do this time. Now, the judge did leave a window of opportunity for his lawyers to come in and try to convince the judge that the 180 days times 4 is too much and to somehow modify his order. So this is a condition of his probation. It's not a sentence of prison time. This is jail time in the Tarrant County Jail where he's been sitting since he was returned from Mexico. And those days did not count towards these 180 days.
Oh,
so,
no credit for that.
No credit for that. And then he gets out. If, say, he does this 720 days, then he gets out and he will still be on the probation that he was put on when he took this case to court back in 2014. So he'll be 2 years into the probation that started, yesterday or Monday. So he'll have another 4 or 5 years left on probation, for which if he then violates his probation, he could then be sent back to prison for up to 10 years, and without any credit for those days of condition.
Okay, I guess this is where I get a little bit confused. So he's on probation, but the most the judge can give him is 180 days per count, and he had 4 counts because there were 4 victims of his drunk driving. So how come it is that is this just a provision in the Texas law where the judge can only give him 180 days, and then if they violate a second time, he can go back and give him more? Why is that? Why is there a limitation on the first time here?
The 180 days is in the Code of Criminal Procedure that in every felony case, that any judge and every judge has 180 days to play with. And a lot of times judges will send the probationer to jail on their birthdays, on Thanksgiving, on Christmas, on the victim's birthday, or their anniversary, depending on the facts and circumstances of the case.
All right, something symbolic. Okay. All right, I get it.
You can do 30 days here, 30 days here. What Judge Salvant has done is gave Mr. Couch 180 days, and then when he's done with the first 180 days, we're going to go to the second case. And you can do another 180 days for that victim. And then when that's done, the third and the fourth victim that he killed, he's going to serve those consecutive. Now, most terms and conditions of probation, such as community service or drug rehabilitation or alcohol classes and courses, are all run concurrent. They don't make you take them 4 times.
Right.
But in this particular condition, he's actually running them consecutive. He stacked them. And obviously he was doing that to be punitive and to send a message that he's not tolerating the behavior that he's heard about but didn't have jurisdiction over. I think it's possibly because Mr. Couch ran to Mexico and basically thumbed his nose at the system. Salvant said, you know what, I'm going to fix this. I'm going to give you 2 years, which is a long time to spend 23 hours a day by yourself. They have to segregate him away from the general population because he's public enemy number 1 out here in jail. Someone would love to have a piece of him, I'm sure.
Yeah. In more ways than one, actually, I bet.
Yeah, exactly.
Scott Palmer is our guest here, scottpalmerlaw.com. And Scott, so this was a probation violation then, and that's why the judge can toy with it? Or this is just the judge is just exercising his probation rights anyway?
Exactly. This is not a probation violation. It looks like one, but it isn't.
Oh.
The judge is exercising his discretion to send him to jail for 180 days on each case. Some judges exercise 0 days in jail as a condition of probation. This judge has decided to institute the full maximum 180 days and run them consecutive to each other.
So why is this not a probation violation then? It seems to me that if you don't show up for your probation, you take off to Mexico. That would be
right.
Pretty obvious. I think so anyway, but there must be a reason behind it.
Well, when he did that, he was on juvenile probation. So there would have been a probation violation under the juvenile court system, but what they did is they transferred him to the adult court. And now that he's in the adult court, he basically starts clean. He starts a fresh start, so to speak, and the adult system is different than the juvenile system. So they didn't adjudicate him or revoke his probation and sentence him in juvenile court. They said, we're going to let the adult court deal with that. We're going to pass on the Mexico jaunt that he went on. But essentially, when Salvant gave him the 2 years, I think he was rewarding him with that by saying, you went to Mexico, here's what you're going to start your probation with in my court. But, of course, there was no petition or a motion to revoke his probation pending on Monday when he made his first appearance in adult court, because he hadn't violated his probation in adult court because he hadn't started it yet.
Oh, see, this is where it gets a little bit tricky, because we're talking about two different courts here simply because the guy had a birthday.
Correct. Absolutely right. This is not a probation violation, though it looks like one.
Okay.
But it's not technically.
So talk to me then, Scott Palmer, scottpalmerlaw.com, legal expert. Talk to me then about his mother, because I know there's a gag order on this deal with Ethan Couch, because the mother is still facing trial, and we know that's in grown-up court. What is that going to entail?
That's in the same court.
Yeah.
Well, what's interesting about that situation is I do not believe, my information I have on this case, I've been following it closely, is that his mother has not been indicted at this point. So the Tarrant County grand jury has not convened and has not looked at her case yet. And I would not be surprised that when they do, and if they do, they may not even indict her. There are a lot of legal problems and technicalities with indicting her for hindering the apprehension of her fugitive son. Did she factually do it? Absolutely. Did she do everything in her power to get to Mexico and secrete him and hide him? Absolutely.
Yeah.
But legally, this is where it gets a little tricky, and she's got a good lawyer. And the lawyer will likely argue to the grand jury in a presentation that the lawyer will make if the case ever gets presented, that because Ethan Couch wasn't committing a new offense, leaving the jurisdiction and leaving your probation and jumping ship is not a crime in Texas. It's a violation of this probation, the contract that he had with the judge, the juvenile judge, but it is not a crime. So when she did not help him and aid and abet him in committing a new crime, she, in fact, did not commit a crime herself, is what I would argue if I was her criminal defense lawyer. And there's cases on it, and she may never actually be prosecuted.
Is this something the Texas legislature may look at then and decide to make it some sort of a crime? Or is it just not worth their time?
That's exactly right. I think that if this case ends up going the way I foresee it going, the legislature will either add a new element to the Code of Criminal Procedure, or the Penal Code, which will say that a person who aids and abets a person on probation is, in fact, committing a new offense, is committing a crime themselves. Currently, the case law that interprets this says that she didn't commit the crime. That's my take on it. Others may disagree, but I've looked at this pretty hard, and I've done many interviews on this very issue, and I think that she is not going to face the system. I mean, I think she's going to actually either get no bail by the grand jury, or the DA's office will just throw up its hands and say we can't prosecute her because the law won't let us.
Wow. Listen, you have enlightened us. Scott Palmer, scottpalmerlaw.com. Scott, I hope we can talk to you again as this case, if something else transpires on this, if there's another chapter to it, an advancement on this, I hope that we can come back to you because you're just great, man. Thank you so much for the insight.
My pleasure.
All right.
Give me a call anytime.
We'll do it. Scott Palmer, scottpalmerlaw.com. Still to come.